ಲೈವ್ ಇದೆ ಅದು ಲೈವ್ ಮಾಡಿ. ಎಲ್ಲ ಇದೆ ನೋಡೋಣ ಏನಾದರೂ ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ ನಾನು ಕಳಿಸಿದ್ದೆ ಚೇಂಬರ್ಗೆ ವಾಪಸ್ ತರಿಸ್ಬಿಟ್ಟೆ. 3 ಸೆಟ್ ಅಲ್ಲಿ ಕಳಿಸ್ಬಿಟ್ಟಿದೆ. ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ ನಾನು ಕಳಿಸಿ ಮಂಜುಳಾ ಮೇಡಮ್ ಹೇಳಿದೆ ಫುಲ್ ಬೆಂಚ್ ಬುಕ್ಸ್ ಇದು ಕೊಡಿ ಅಂತ ಕಳಿಸಿದೆ. ನಿನ್ನ ಹತ್ರ ಒಂದು ಸ್ವಲ್ಪ ಕೊಡ್ಲಾ ಬುಕ್ಕಲ್ಲಿ ಇಡ್ಲಾ ಕೊಡು ಮಾತು ಮಿಸ್ ಆಗಲಿ ಇಲ್ಲಿ ಒಂದು ಎರಡು ಇಟ್ಕೊಂಡಿದ್ರೆ ಒಳ್ಳೇದು. ಅದು ನಿಜ ಅದು ನಿಜ. ಇದೇ ಕೊಡೋದಲ್ವಾ? ನಂಗೆ ನೋಡಪ್ಪ ಅಷ್ಟೇ. ನೀರ್ಲೆ ಬುಕ್ಸ್ ಅಪ್ಪ ಇಟ್ಕೊಳ್ಳಿ. ಇರ್ಲಿ ಸಾಕಾಗೋಗಿದೆ ಅಲ್ವಾ? ಊಟ ಮಾಡಕ್ಕಂಗಿಲ್ಲ. ಇದು ನಿಮ್ಗೆ ಆ ಕಡೆ ಹಾಕ್ಸ್ಬೇಕಾಗುತ್ತೆ. ಚೆನ್ನಾಗಿದೆ ಅಲ್ವಾ ಇದು? ದಿನ ಅದು ಹುಡ್ತಾನೆ ಅಂತ ಕೂತ್ಕೊಂಡಿದ್ದೆ. ಅಟೆಂಡ್ ಮಾಡ್ತೀವಿ. ಹೌದಾ? 9th of December, 9th of February. ಎರಡು ಮಾಡಿಸ್ತಾರೆ, ಎರಡು ಮಾಡಿಸ್ತೀವಿ. ಎರಡು ನಿಮಿಷ ಬಂದ್ಬಿಡುತ್ತೆ ರೆಡಿಯಾಗಿ. ಡಿಸೇಬಲ್ ಆಗಲ್ಲ.
May I have your lordship's kind permission, my lord, to bring
Yes.
to the notice of the court, since the last hearing, my lord, we have compiled a compilation and it has been filed, my lord, on the 7th of January. Your lordship had seen the various government orders with the list. This compilation, my lord, gives a little elaboration. It gives, my lord, in regard to each increase or decrease by virtue of the notification. This is nothing but a compilation, my lord, of the information that I've already given with this explanation. The lordships may kindly peruse it and take it on record. I've served copies on the other side also.
Yes,
It
yes.
shows exactly how 155 cadre strength in 2003 became 314 in 2005. With regard to each government order, what is the effect of it and how the cadre strength goes up and down, Lord, is there in the tabulation. It's, my lord, a memo dated 7th January 26.
ಇಲ್ಲ ಅದ್ರಲ್ಲಿಲ್ಲ. I think we'll continue from where we left off last time, and then we'll come to the chart. We'll come to the chart.
I just wanted to please inform your lordships, my lord, that I have filed this, and if necessary,
Yes.
I'll elaborate later, my lord, after others finish.
Yes. Yes.
Lords, when the matter stood over last time, I had taken my lords through the dissenting view expressed in the, I can't say dissenting view, contrary view expressed in the division bench judgment. And I also pointed out that ultimately the point of difference is one, that is about 32 posts being taken as part of the cadre strength. And relief has been granted on that basis. Of course, another observation has been made in para 101, but that is only a pious declaration for the future. Therefore, it does not affect the impugned seniority list. Now, my lords, my endeavor would be on facts, even if 32 posts which have been inclusion of which have been found fault with is accepted to be correct. I am not saying whether it is correct or wrong at this stage, because High Court has justified inclusion of those 32, and I cannot improve upon what the High Court says, because it is for the author to explain, and author has explained. Assuming for a moment, my lords, that the finding given that the 32 posts being not permanent posts could not have been included in the cadre strength for determination of the quota, whatever be the reason. My submission would be, even if those 32 posts are excluded, the direct approved petitioners cannot come above us in the seniority list. To make good that point, my lords, I have filed a short memo I am filing. If my lords may kindly have a look at it. My first submission would be, even if the findings are accepted to be correct, out of the 32, 8 posts will have to be ignored. For the reason, I'll point out from the cadre strength notifications filed earlier. I am not commenting on what they have filed today. If my lords would kindly take this memo dated 8/9/2025, that was filed before the division bench, by the High Court.
Notifications.
ಅದ
Standard ಇದೆ ಅದರ ಇಲ್ಲ notification. All these notifications and all they have filed. No? This notification 8/9. Same.
Yes.
Our promotions, my lord, there are 2 batches of promotees. First batch of promotees, they are promoted on 30th March 2015. That is annexure R1, page 746. The second batch whose seniority is questioned, they were promoted on 30th August 2015. That is document R2/749. Now, notice, can we take this summation of the cadre strength notifications? It starts at page 1 of the memo. Last 4 entries are at page 4. That is item 37, 38, 39. These are, my lords, according to the High Court, taken into consideration for cadre strength on 1/9/2015. First, they give the date of the notification. Second, they give the number of posts. Third, they give the date on which they were taken into consideration. Therefore, on the date we were promoted, these had not been taken into consideration. And these are the three items of posts created that have been found fault with by the division bench or one of the learned judges constituting the division bench. That is at paragraph 96. Para 96 the division bench judgment. At page 148 of the judgment. That starts saying the notifications dated 22/9/88, 15/2/2008, and 29/1/2015 relate to 8 posts of additional registrars. Then it goes on. Then, it concludes saying the procedure is not in accordance with, thus these 8 posts cannot be considered as part of the cadre strength. And notifications may be dated anything.
29/1/2015. Correct, but there is very data. Same.
Notification shot 22/9, 15/9, but they have affected on 1/9/2000. The date is considered.
Yes.
Therefore, my lords, insofar as our seniority assessment is concerned, the posts that should be really excluded will stand reduced to 24. Because 32 posts is the posts identified by the learned judge. 8 of them were taken into consideration as part of the cadre strength long after our promotions. Long or short does not matter, anyway after our promotions. Therefore, to assess the cadre strength at the time when we were promoted, what would really happen is 24 of the posts stated by the High Court will have to be reduced.
It will be reduced to 24.
It will be reduced to 24. Huh?
It will be, my lords, if the learned single judges, if the learned single judges, view is accepted as correct, the reduction in cadre strength would be 24 for the purpose of assessing our seniority. I am not saying that they have to be reduced. I am making my submissions, assuming that the learned judge is right. In arriving at the figure 32, arithmetical exercise is right, but application of that to the service jurisprudence is wrong, is my respectful submission.
So it comes to conclusion that these additional posts are created not as a cadre. The existing posts they are in 32, where each case for the accordingly these 8 also required to remove them because that is after their promotion. So this error,
Even if it is accepted,
you can't accept it, but even accept also this 32 is wrong.
So you're saying even if you were to exclude,
Yes,
without admitting the correctness.
yes, my lords. To test the validity, my lords, ultimately, on that finding, whether the seniority list could have been set aside. My respectful submission is, even if they are excluded, there would be no change in our seniority. Therefore, the learned judge could not have said that the seniority list is invalid.
So it will come to 24 according to you.
It is 24 because on the date we were promoted. The case of the petitioners is we were in excess of quota. To show that we were in excess of the quota, 32 posts are excluded with the learned judge. My submission is what he could have excluded is only from amongst the posts taken into consideration as cadre strength on the day we were promoted. And on that day, these three items, 37, 38, 39, had not been taken into consideration by the High Court for calculation of the cadre strength. They were added to the cadre strength for computation of the quota by the High Court only on 1st September 2015. Before that, we were promoted. Therefore, 32 becomes 24. That is my first submission. Then, my lords, first of these batches, we were promoted on 30th of March 2015. That date I have given, and that is annexure R1 and R2. I will just take my lords to those promotion orders. Page 749. Page 746 is the first notification.
Third volume. Third volume.
Page 740. Date of promotion is 30th March 2015, and by this notification, 39 of us were promoted. Therefore, what would be the cadre strength on 30th March 2015, even if the posts ordered to be excluded by the learned judge are excluded, what will be the position? No, my lords, if the cadre strength notifications which I was referring to are taken into account. No, my lords. What would stand excluded are items 1, 2, 3, which are taken into cadres of the 1, 2, 3 of this memo, each of them one post each. This High Court ಮೆಮೊದಲ್ಲಿ ಕೊಟ್ಟಿರೋದು cadre strength.
Yes. Yes, it is.
My lords, I have it. They are having it. What the learned judge has found fault with are para 87 at page 138. He speaks. The notification dated 15/2/2002, serial number 1 of the memo filed by the High Court relates to a court created for purpose of conducting trial of a case relating to Dandupalya Krishna Bank. Another notification dated 15/2/2002, serial number 2 relates to court created for the purpose of conducting trial of a case for stamp paper case. Then, my lords, little below in that page, further the notification dated 27/12/2003, serial number 3 of the memo relates to the court created for conducting trial of the case involving late Kumari Jayalalitha. These three courts are temporarily created for the purpose of conducting trial, and upon consideration of such trial, the said courts would stand abolished. Even otherwise, the trial of cases in the of these three have been concluded several years ago, and there is no notification for continuing such courts thereafter. Thus, these three courts cannot be taken into consideration. That is the finding. Therefore, items 1, 2, and 3 are required to be excluded according to the learned judge. Then, the next finding at page 88, at para 88, it pertains to item number 7. Item number 7 also, the learned judge says should be excluded. Then the next finding is in respect of item 8, that is at para 89.
Just 1 minute.
This notification for chart, High Court has filed. No, long back, before the division bench, 8/9.
I'm referring to only old memo because
This, you take your first page. This is chart prepared by the High Court. First page, not this first page. Yes. This
7 is found fault with at para 8, 88. 8 is found fault with para 89. Therefore, my lords, items 1, 2, 3, 7, 8 are required to be excluded. 8 actually, it would not affect my promotions because though it is notification is of 1991, it is taken into cadre strength only on 1/8/2005, before the first batch of promotions, after the first batch of promotions are ordered on 30th March. What the High Court says we took into account on a particular date is, though the posts had been created, we did not fill up those posts or we did not make promotion or appointment to those posts. That post was taken into consideration for appointment only on 1/8/2005. And the employer is always having a right. There is no compulsion on the employer under the Constitution that every post in the cadre should be filled up. He can leave some posts vacant. That discretion is always available. Therefore, in any case, 1, 2, 3 and item 7 will have to be excluded. My office, my lords, while preparing the memo, they have excluded 8 also. Therefore, for arithmetical purposes, I take 8 also for today's submissions. But a revised memo may have to be filed depending upon the further proceedings in this case. Assuming, my lords, the total number of posts that will have to be excluded will be 4, but even taking it as 5, the cadre strength as on 30th March 2005 will come to 172 is the figure given by the High Court. 5 or 4 of it will have to be deducted. It comes to 168 if 4 is deducted. It will come to 167 if 5 are deducted. Therefore, this figure may be kindly taken as the cadre strength as determined by the learned judge as on 30th March 2015.
2015 is the date of promotion for them. As on that,
I'll come back to how these 305 posts will have the 167 posts or 168 posts will have to be appropriated against 3 quotas. I'll come a little later. Then, my lords, the second of the promotions Second batch took place on, that is at page 749, annexure R2. That is on 13th August 2015. On 13th August 2015, 41 promotions are made. Now, my lords, as on 31st March 2015, the 13th August 2015, 13th August, the cadre strength calculated by the High Court in its first memo, it is 308. That is at page 3 of that earlier memo. (307). Out of that 307, 24 posts are to be deducted. This is taking the totality of the findings of the learned judge. If 24 is deducted, it comes to 283. Therefore, my lords, on the first, on the facts pleaded and accepted by the learned single judge, even excluding the posts found fault with, the cadre strength as on 30th March 2005, 2005 will be 168, and on 13th August 2015, it will be 283. This should be the cadre strength without disputing the figures formulated by the learned judge. Now, my lord, the next question, whether there was quota available for promotions to the extent of promotions made by annexures R1 and R2 on the respective 2 dates. Now, here, my lords, 3 things we'll have to remember. First is, my lords, until the advent of 2004 recruitment rules, there was no quota for direct recruitment. That I have submitted on the last occasion, taking my lords through the contents of the 1983 recruitment rules, as also 2 judgments, one of the Supreme Court, that is that is my lords, yes, Ashok. What is in my compilation volume 1? Taking my lords through 2 judgments, that is yes, Ashok Kumar, judgment number 15 in my compilation of the Supreme Court, where identical rule in vogue in the state of Madras was interpreted by the Supreme Court and said that there is no quota. That is, my lords, yes, Ashok Kumar.
Part of the written submission, is it?
Yes, my lords.
These judgments are part of the written submission.
Yeah, they're part of the compilations I have filed. Huh? Synopsis and mention ಮಾಡಿದ್ದೀನಿ ಅದನ್ನ. That is volume 2 of the compilation, judgment number
2.
Judgment number 15, page 286.
Volume 222.
Page 2.
286.
There is also at placitum B at page 287. It starts, my lords, having given our anxious consideration. 2 lines below placitum B.
Yes.
Having given our anxious consideration to the contention raised, we find that the basis of the rule position, it is difficult to accept the contention. The language couched in Rule 2B of the TN State Higher Judicial Service 1982 would make the matter clear that appointment to Category 2 of the district is from 2 sources, namely recruitment and transfer from the category of subordinate justice in Tamil Nadu and by direct recruitment. While more than 10 posts shall be filled or shall be reserved to be filled by direct recruits, it does not indicate that it is meant to be up to the maximum of 1/3 of the post. Had the percentage been linked with the total square strength, certainly the direct recruits are entitled to occupy 1/3 of the post from the date of their affiliation and get seniority from the date of their appointment, subject to some successful completion of probation, irrespective of the fact their earlier promotion given. Unfortunately, Rule 2B does not prescribe any quota. This is the finding given.
Correct. Rule note.
Then, my lords,
Huh?
in the next page at page 289,
No, but are you saying that this rule is parimateria?
it is parameter. I will point out. my lords. Kindly take judgment at page 289. In page 289, the judgment rendered by this court, rule is extracted. Our rule is extracted at para 8, page 298. The next point for consideration is whether the Karnataka Judicial Services recruitment rules provides for any quota for direct recruitment in the cadre of district judges from the bar. The method of recruitment to the post of district judges in schedule to Rule 2 of the KJSR rules is district judges by promotion on the basis of seniority cum merit from the cadre of civil judges, provided that such number of posts as may be determined by the High Court from time to time, but not exceeding the in the aggregate 33%, 1/3% of the posts in the cadre of district judges may be filled by direct recruitment. In Tamil Nadu rule, it was not more than 10. Here it is not more than 33 and 1/3%. That is the only difference between the two rules. And my lords, may I take the rule itself? Rule is at the recruitment rule has been placed before the division bench. That is at in the third volume only. That is at rule to the page. The recruitment rules have been based on record. My lords would get the 1983 rules at page 691.
Third volume.
Page 691. Volume 3 of the writ appeal.
Of the writ appeal.
All references I am making only to the High Court's writ appeal because
Page number.
page 691. Item 2, district judges, by promotion on the basis of seniority cum merit from the cadre of civil judge, provided. The first part is by promotion from the cadre of civil judges is the rule. Proviso is that such number of posts as may be determined by the High Court from time to time, but not exceeding in the aggregate 33%, 33 1/3 of the posts in the cadre of district judges may be filled by direct recruitment. It is a permissive provision and not a definite quota. Therefore, my respectful submission is 1983 recruitment rule did not provide for any quota for direct recruitment. The language of the rule is High Court may determine how many posts will have to be determined by filled by direct recruitment, but such determination shall not exceed 33 and 1%, 13%. It could be 0 also. We say that there is a definite quota when there is a definite quota. Here there is no definite quota.
But how has it been interpreted? Take us back.
How it has been interpreted? Supreme Court interpreted the rule in Ashok Kumar. Then learned judge of this honorable court, Lordship Justice Gopal Gowda, interpreted in Shambulingappa. In the earlier round of recreation in Registrar General High Court versus this one, which the earlier immediately prior judgment, these two judgments are not brought to the notice of the division bench. I do agree that learned single judge's order would have been only persuasive, but that was not used to persuade. It was just ignored. And more importantly, binding precedent in Ashok Kumar's case, that was not placed before the division bench. To that extent, the determination rendered on the interpretation of 1983 recruitment rule by the earlier division bench is not binding. It would be per incurium. That is in Rudramani's case.
Just go back to Ashok Kumar on the interpretation of this.
Yes, I'll take my lord back to the Ashok Kumar. Ashok Kumar, page 286. Paragraph 3 at page 286. Sri Palasharan, the learned senior counsel for the appellants, has contended that the High Court has committed serious error in not giving the direction for the appellant's confirmation to the substantive force. Interstate seniority between the appellant and the contesting respondents would flow from that direction. He contended that the state government had fixed 31 posts of district and session judges, out of which 18 are for the district and session judges grade 1 and grade 2 for district and session judge grade 2. In the seniority list published from the government, the placement of 28 to have been kept blank, which meant that they are reserved for the appellants. The High Court admitted of their appointment to substantive vacancies, irrespective of the fact that the contesting respondents were promoted earlier in the point of time. The appellants are entitled to be fixed in the vacancies kept reserved for them in the placement 28 to 33. In that, by direct recruitment, they should rank in that regard. He contended that once the appellants have been appointed substantially by direct recruitment, they should rank senior to the officiating promotees, and therefore the High Court has committed serious illegality in not giving direction in this behalf. These are the facts. Having given our anxious consideration to the contention raised, we find that on the basis of the rule position, it is difficult to accept the contention. The language couched in Rule 2B of the TM State Higher Judicial Services 82
would make the matter clear that appointment to category 2 of the district and is from two sources, namely recruitment by transfer from the category of subordinate judges in Tamil Nadu State Judicial Service or by direct recruitment. While making a recruitment, the proviso limits its operation that out of the cadre, not more than 10 posts shall be filled or shall be reserved to be filled by direct recruitment. It does not indicate that this is meant to be up to a maximum of 1/3 of the post. Had the percentage of these posts been linked with the total cadre strength, certainly the direct recruits are entitled to occupy 1/3 of the post from the date of their application get seniority, subject to successful completion of probation, irrespective of the fact whether they have been continuously officiating or this one. Their earlier promotion and continuous officiation would not inure to their advantage, or they will be put from giving place. Unfortunately, 2B does not prescribe any quota. It would mean that at no point of time the direct recruits would exceed 10 in number. Here, wherever that word 10 appears, read it as 33 and 1/3% in number. Identical rule, this is how it has been interpreted. Therefore, my first submission is the posts that were in existence during the time when 1983 rule was in operation, all those posts will have to be treated as promotional posts only. Because in-service LCDE was not known those days. It is a later day development. And direct recruitment, there was no definite quota. Certain posts were permitted to be filled up by direct recruitment at the discretion of the High Court. Therefore, the cadre strength that existed at the end of 1983 rule will have to be treated entirely as quota reserved for promotions.
No, he says that everything should be understood as a promotional quota only, like LCD examination. But direct recruitment quota was there, no?
There was no direct recruitment quota
Before 83.
No,
before 83. Under the 1962 rules, some quota might have been there. At the end of the 1962 rules, the number of posts that were in existence were very few. And that has not been treated also by the direct recruiters. 1962 rules, my lords, I am sure there would have been some quota. Yeah. 1982 recruitment rules, my lords, are at page 774. There also, it was only as nearly as. It is page 774 of the paper book is the 1962 rules. There, my lords, it said as nearly as maybe 33%. There is no pleading anywhere, my lords, nor any figure is available from the figures given by the High Court. What was the cadre strength as at the end of 1962 rules? Because 1983 rules commenced on 30th August 1983 is the date of commencement of the 1983 rules. That date, my lords, would get at page 691.
Now, just one question, you can just keep it in mind.
Yes.
At some point, how far back can we go? Now, let's assume.
That is why, my lords, on the basis of these pleadings, we can go back only up to 83 recruitment rules, because 83 recruitment rules were in force until the year 2005. My lords, in fact, the 1983 rules came to an end on 9/9/2005. And the prayer of the writ petitioners is to recompute the quota from the 1983 recruitment rules. Therefore, what happened prior to 83 recruitment rules is not pleaded and made a subject matter of dispute. Therefore, we can commence our discussion only from 1983 rules.
So according to you, a plain reading would indicate that till 2005, there was only an upper limit of up to 33 and
Yes.
1/3%, but it doesn't mean it has to be filled up to that much.
No, it cannot be a quota. For example, Manoj, in the reservation in promotions, 27th April 1978 reservation notification, if my lords would take. The extent of reservation was when the reservation in promotion will be available for scheduled castes and scheduled tribes was stipulated like this. Where there is a the reservation in promotion will be available up to the lowest category of Group A. In cadres where there is direct recruitment, but direct recruitment quota does not exceed 66 and 2/3%. Suppose, my lords, in cases where direct recruitment quota exceeds 66 and 2/3%, reservation and promotion will not be applicable. A question came before this honorable court. I tried to find out that judgment because it is of almost of 25 years vintage. I could 25 or 26 years of vintage, because Mr. Yashwin Narasimhan appeared for the petitioners and I appeared for the respondents there. There, my lords, the quota was somewhere like this, my lords. It was somewhat like this. Posts up to 66 and 2/3% can be filled up by direct recruitment. The question that was required to be answered by this court is, the quota rule says up to 66 and 2/3% may be filled up by direct recruitment. Whether it amounts to fixing a quota for direct recruitment at 66 and 2/3%. Because if it is fixed at 66 and 2/3%, then no reservation will be available. If it is something less than that, reservation will be available. Then this court took the view that up to 66 2/3% does not provide a quota. It is only permissive. Once it is held to be permissive, even replacement theory will not apply. Suppose, my lords, there is a definite quota which is linked to the cadre strength. Then whenever a vacancy arises by retirement of direct recruit, it should be filled up by direct recruitment. Whenever a vacancy arises by retirement of promotee, it should be filled up by promotion. Once it is held that the quota was only permissive, it was not a quota as understood, a definite quota, then theory of replacement also will not apply. In such an event, for cadre management, promotion direct recruitment quota is non-existent. If the High Court wants to fill up a post by direct recruitment, it can do so, subject to non-hindrance of promotee's rights by application of replacement theory. On the plain language of 83 rule, there was no quota. Therefore, my respectful submission would be number of posts that were in the cadre strength up to 8/9/2005 will all have to be treated as promotion quota.
Yes.
On 8/9/2005, the cadre strength, again going by this notification, after making the exclusions found fault by Leonard Judge, page 1 of that memo, it comes to 172 as on 1/8/2005 is the cadre strength. Thereafter, there is no addition to cadre strength until the year 2006. Therefore, the cadre strength as determined by the Leonard Judge would be 172 minus 5, minus being items 1, 2, 3, 7 and 8. Therefore, these 167 posts will have to be treated as promotion posts. Then, my lords, 2004 rules came into effect. These 2004 rules break into two segments. One is up to 1/1/2011. Up to 1/1/2011, under the 2004 rules, quota was 50% for promotion, 25% for direct recruitment, 25% for limited departmental competitive examination. Here definite quota is provided. I will take my lords through the rule. Then, my lords, from 1/1/2011, it became 65% for promotion, 10% for LDCE, and 25% for direct recruitment. Now, my lords, how these vacancies how these posts will have to be allocated is the question. When the quota is linked to the cadre strength, Supreme Court has laid down what can be taken into account for fresh allocation is only increase in the cadre strength from time to time and not the entire cadre strength. This is based on one principle, my lords. Suppose this rule came into force on 5/9/2005. Suppose until 4/9/2005, 100% of the posts have been filled by promotion and promotees are already holding office. You change the quota from 100%, you reduce it to 50% on 5/9/2005. If this modified quota is applied to the entire cadre, what happens is promotees who are regularly substantially promoted when the quota permitted them to be promoted they would become illegal appointees. Unlike vacancy-based quota members, where quota can be applied to any new vacancy arising. When we are applying it to cadre strength-based quota, what can be taken into account for fresh allocation of posts is only the increase in cadre strength. I'll just point out one judgment and thereafter I'll take my lords to the calculations. My lords may kindly take not one but two judgments. One is, that is, my lords, first I will take judgment number 2 in my compilation, that is at volume 1. That is 2019 12 SCC 496. Page 20, my lords, the judgment commences. My lords may kindly turn to para 48. Which is at running page 44. It is better we read from para 46 onwards. Because factual background also it will give. In the impugned judgment, the High Court has taken a view that since 50% of 107 cadre strength comes to 53, 5 promotive officers were in excess, since working strength before 2008 selection was 58. The above calculation has been arrived at by determining 50% of 107. Whether any fallacy, calculation has been, whether any fallacy is committed by the High Court in the above determination is to be examined. On the face of it, the determination of mathematical calculation, taking 50% of cadre strength for promotees comes to 53. Thus, whether 5 officers who were found in excess were in excess of their quota is one part of the question. And the other part of question would be that what number of vacancies have to be earmarked for out of turn promotees under Rule 73B. We have already noticed that from 28/191, Rule 8 was amended for providing for 3/4 to the cadre to be filled by promoting officers and 1/4 by direct recruitment. The above position continues till the rules were amended in 2004 under the direction of this court under All India Judges case. I will pause here for a moment, Manoj, and say that this position that 100% promotion continued until 4/9/2025 until the court, our High Court amended the rule in the year 2004 pursuant to All India Judges 3. For the first time, by amending the Punjab Superior Judicial Service on 15/1/2004, promotion under quota under Rule 8 was fixed as 50%, 25% for limited departmental competitive exam, and 25% for direct recruits. And as far as direct recruits, earlier 25% was maintained. Here, factual situation, there was no 25% for the direct recruitment earlier to the amendment. Thus, the issue was only with regard to quota for promotion on the basis of merit cum seniority and out of turn promotees. This court in All India Judges 3 in para 29 has clearly directed that the system which was directed to be put in place by this court, whether para 27, 28 and 29 was to apply prospectively. This court had directed that appropriate rules and methods will be adopted by the courts and approved by the states wherever necessary by 31/3/2003. Up to 2004, the quota for promotion on the basis of merit cum seniority was 75%. The cadre strength as on 13/9/2000 was 89.
which was increased on 10/11/2007 as 107. They note the existing cadre strength and addition. After the amendment of rules on 15/1/2004, promotion of 10 officers was made. It is mentioned in the civil appeal of the High Court that cadre strength of Supreme was 88. Thus, in the year 2004, when cadre strength was 88, 75% were manned by promotees under merit cum seniority, 66 were to be manned by promotee officers. The judgment of this court in All India Judges case being prospective, the ratio of officers as existing before unamended rules cannot be adversely affected. A promoted officer before the amendment of 2004 rules who was well within their quota suddenly cannot go out of their quota and become an excess merely on the strength of amendment of rules which are prospective in nature. For determining quota, the cadre strength which existed prior to amended rules and subsequent to the amended rules have to be treated differently. Promotees quota, which was 75% prior to the 2004 rules, makes 66 posts in their quota as before amendment dated 15/1. When the cadre strength has been increased from 89 to 107, 18 posts have to be further added to the cadre. This increase having been made after the amendment of the rules dated 15/1/2004, on this cadre strength, the rules as amended will be applied for bifurcation of quota. Here it has to be treated as trifurcation of the quota because direct recruits had no quota before amendment. On 18 newly created posts, 50% comes to 9, for out of 10 promotees 4.5 and for direct recruits 4.5. Thus promotees on or after the increase of the cadre could have been 66 plus 9, that is 75. In the appeal filed by the High Court, it is also indicated 10 promotees with the rule providing 21 of being in place, at least few vacancies ought to have been given. There is no detailed decision. The out of promotion quota having been culled out only as per the judgment of this court in All India Judges case, which was to be required in the rules by the state, said quota will come into existence only prospectively. An out of 10 promotee cannot claim they should be given 25% post of the cadre strength right from day one. It is true that quota has to be determined on the cadre strength, but determination of cadre strength has to be made taking into consideration that rules amended with effect from 15/1/2004 were prospective in nature and cannot impair or affect any right which accrued to the member of the judicial service prior to the amendment of the rules. This is the finding. With this finding, if we go to the cadre strength as determined by the High Court and as axed by the learned judge, as on the date of commencement of 2004 rules, that is 8/9/2005, 9/9/2005, the cadre strength, as per this tabular statement given, ends at item 8, 172, of which 5 have to be excluded. It comes to 167. Therefore, as on commencement of the 2004 rules, 167 posts were available to the promotees. They should be continued to be available to the promotees even after amendment. Then, the first promotion was on 30th March 2005. As on that day, cadre strength would be the 30th March 2015. 30th March 2015, the cadre strength would be
259 as determined at page 3, item 35, minus 24 found fault by the learned judge, it will be 235. Of these 235, 167 posts that existed at the commencement of the 2004 rules are promoted quota. What is available for allocation afresh will be only 68 posts. These 68 posts will again be divided into two broad categories. That is 199 as on 31/12/2010. That is item number 23 at page 2 of the tabular statement. Minus 199 minus in the first page 11, in the second page 2, 199 minus 13, 186. Of them, 167 will have to be treated as promotional quota posts. Then what will be available for allocation between the three streams will be 50% of 19.
50% of
50% of 19 will go to promotees. 25% of that 19 will go to direct recruits. The remaining 25% will go to LDC.
we got your point, but you'll have to make a chart.
I have tried to make it in the memo that I have given.
No, but we got it. So you're saying that this amended rule
Yes,
will
ma'am.
come into play only insofar as the new
Additions to the cadre strength is concerned. If it is a vacancy based quota, the position would have been different. This is the difference, my lord. One thing it is very easy to say that post-based quota would reduce the litigation. That is what was said in All India Judges case 3 by the Supreme Court. Why they wanted you shift from vacancy-based quota to post-based quota was that in the last 3 decades we have observed huge litigation is there regarding seniority. If it is made, if the quota is made post-based, this would be avoided. That was this single object with which the Supreme Court directed making of the post-based quota. Of course, in our state, we had this post-based quota right from 1962 rule. But only thing is, the 1983 rules provided a permissive filling up of direct recruit, did not provide this. Thereafter, my lords, now, after 1/1/2011, the addition to the cadre strength is, that is, before we were promoted, It will be 259 minus 24 as ordered by the Learned Judge. It will be 235. 235 minus 167. It is 68 posts. Of this 68, 19 we have already allocated as on 1/1/2011. What remains is 49. That has to be allocated as 65% for the promotees, 25% for direct recruitment, 10% for LDC. After making all these allocations, my lords, the total number of LDCs that could be in the cadre, it will come to, my lords, maximum, it would come to 11 or 12. As against this, the number of LDC appointments made were, I'll point out from the impugned seniority list, that is Annexure N. Annexure N, my lords, is at page
548.
548. 548, if the honorable court looks at 548, this is the seniority list that was impugned. What has really happened is, in service page 552, my lords may take 30 13 again. On a most liberal calculation, I have said in that synopsis file today, 13 LDCE could have been there. What has happened is, the seniority list commences at page 548. Between serial numbers 99 to 159, 99 is at page 552, 159 is at page 557. In between these two numbers, the LDCE are 47. 47. First. Almost all of them have retired, I think, except a few, like some of them are still there. For example, 157, Prakash L. Nadiger. He is born on 14/10/1958, therefore he will still be in service. There are some people who remain in service. Between 55 and 159, so 99 and 159, 47 persons are LDCs. And again, at page 558, three more are there. At pages, at serial numbers 167, 168, 169. As against 13 permissible, 50 persons have been appointed as LDCE district judges. It is these 37 who have to go out of the seniority list. Out of that 37, 24 will have to go out of the seniority list because 13 was the quota available. Even on the date when we were promoted. Therefore, the real challenge should have been against inclusion of these 50 and not inclusion of the promotees. I don't say that the seniority list is correct, but the wrong is somewhere else. I cannot be pushed down, is my case. And no pronouns to push them out can be given by this honorable court in this proceedings because there is no pleading to oust them. No LDCE is made a party. Assuming that while I challenge seniority list, all persons whose seniority I question need not be made parties. Law is, at least in representative capacity, they should be made parties. Even that has not been done. Therefore, my respectful submission is, even if 24 posts are excluded, seniority of the promotees will not be affected. Villain of the piece is the LDCEs, whose ranking is not questioned. Against whom no prayer has been made, and no LDCE is implemented. Therefore, writ petition will have to be dismissed. Because bullet is trained on a wrong group. Ilin hodiri antana Ganapati hodiyak bandidare. They should have trained their gun on the rat and not on the Ganapati. Unfortunately, Ganapati has been ousted from the, I call Ganapati because we are the largest single quota holders. Then, my lords, about I have assured my learned friend that I would give at least half an hour about the. I will file I have filed my synopsis and judgments, and I will take because my learned friend has come from Delhi. Therefore,
But on the next date, we want you to, now what you have explained,
yes, ma'am.
that must be in the form of a chart.
Very well, ma'am. So I'll make the chart and give it. So I'll definitely do it. I'll be. I am bound to assist the court, and I will do it because ultimately that has to be. I will take my lords to the judgments once my learned friend completes, if it is become necessary. Sorry, I took 5 minutes of your time. Thank you, sir.
Yes.
It's my gratitude to my esteemed friend, Mr. Rajgopal, my lords, for yielding space to me. I appear, my lords, for the appellants in Writ Appeal 1312 of 2023, who were private respondents in the writ petition, and in the writ appeal filed by the High Court were respondents 8, 11, 13, 14, 23, and 31. Before, my lords, I address your lordships on the lists in question, please permit me to begin by placing one judgment.
You represent the promotees.
Promotees.
He has also filed one appeal. Now the
Yes.
Permit me, my lords, first, as a preface, to place a judgment of the Honorable Supreme Court in Pankajakshi's case on the question as to the scope of a reference to your lordships in a full bench. My Lords, Justice Yadav had asked a question, how far back can we go? If I may paraphrase that, how far at all can we go in this matter, my Lords, is a question that I would respectfully first place for your Lordship's consideration. Since the matter comes to the court on a reference from two learned judges who have differed, my Lords, in the writ appeal. Now, this was an interesting case, my Lords, which considered the effect of Section 23 of the Travancore Cochin High Court Act. If your Lordships come to para 2 at printed page 167 of the judgment, a Constitution Bench judgment, my Lords. Section 23 is extracted therein. In para 2, the reference order by two learned judges, after referring to Section 98 of the CPC, reads as follows. The above view was followed by a three-judge bench of this court in Hemalata. That was a case in which the High Court of Kerala had, relying upon Section 98 CPC, confirmed the decree under appeal despite difference of opinion between the two judges comprising the bench on a question of fact. This court held that while Section 23 of the Travancore Cochin High Court Act is the general law, Section 98(2) is a special provision. Section 23 of the Travancore Cochin High Court Act reads as under, reference by the Chief Justice. Where two judges forming a division bench agree as to the decree, order, or sentence to be passed, their decision shall be final. But if they disagree, they shall deliver separate judgments, and thereupon the Chief Justice shall refer for the opinion of another judge the matter or matters on which such disagreement exists, and the decree, order, or sentence shall follow the opinion of the majority of the judges hearing the case. Importantly, my lords, a provision akin to 23 is absent in the Karnataka High Court Act. And therefore, we fall back on Section 98 of CPC. That was the difference that the Constitution Bench was resolving in this case. And if your lordships please come to para 4, that point of disagreement or difference is indicated. Para 4, in order to appreciate the controversy which lies in a narrow compass, we need first to advert to the decision in Hemalata. In that judgment, this court has held that the Travancore Cochin High Court Act, Section 23 of which contains a provision which states that if two judges forming a division bench of the High Court disagree, they shall refer their disagreements to the opinion of another judge, and the opinion of the majority will then prevail, was said to be general as against Section 98 of the CPC, which was said to be special. This has been overruled, my lords, in this case. It may be stated that Section 98 in dealing with appeals to a superior court generally has a reference to a third or more judges in the event of disagreement between two judges only on a point of law. If the disagreement exists on a point of fact, the lower court judgment is to be confirmed. Hemalata's case therefore decided accordingly. Now, my lords, considering Hemalata and the interplay between 23 and 98, which Section 98 your lordships find ready reference at page 173. And in our case, it is 98, my lords, that would apply. Decision where appeal heard by two or more judges, Where an appeal is heard by a bench of 2 or more judges, the appeal shall be decided in accordance with the opinion of such judges or of the majority, if any, of such judges. Where there is no such majority which concurs in a judgment varying or reversing the decree appealed from, the decree shall be confirmed, provided that where the bench hearing the appeal is composed of 2 or more, or 2 or other even number of judges belonging to a court consisting of more judges than those constituting the bench, and the judges composing the bench differ in opinion on a point of law, my lords, I emphasize this, they may state the point of law upon which they differ, and the appeal shall then be heard upon that point only by one or more of the other judges, and such point shall be decided according to the opinion of the majority, if any of the judges who have heard the appeal, including those who first heard it. Now, this, my lords, so-called conflict between 23 and 98 was ultimately resolved by the Constitution bench in this case at para 36, my lords, printed page 190. As has been stated by us above, for the exclusion to be specific, we must first hold that the provision contained in section 98(2) is special as against section 23 of the Travancore-Cochin High Court Act. This we are afraid we cannot do, as it would be in the teeth of the Constitution bench judgment in Sathapan's case, in particular para 32 thereof. This court has unequivocally held that letters patent is a special law for the High Court concerned, the CPC being a general law applicable to all courts, and that it is well settled that in the event of a conflict between the two, this special law must always prevail. In the present case, substitute the words High Courts Act for letters patent. What follows is that the High Courts Act is a special law for the High Court concerned, the CPC being a general law applicable to all courts. This, according to us, really concludes the matter in favor of the appellants. Hemlata's case has therefore been wrongly decided and must be overruled. So, my lords, the emergent position is that where there is a special provision in the concerned High Courts Act, that would prevail over 98. When it comes to the Karnataka High Court, where, my lords, such a provision is absent, then 98 would continue to hold the field, and it is on a point of law, my lords, that the reference would be decided by your lordships, keeping in mind the point on which the two learned judges have differed. And this is slightly more elaborated by Justice Kurian Joseph's supplementing but concurring view, which your lordships get at 205. While agreeing, my lords, at para 60, the legislature has thought it fit to allocate certain matters to be heard by a single judge and few by a bench of not less than 2 judges. In common parlance, what is known as single judge and division bench. A matter is stipulated to be heard by a division bench on account of the seriousness of the subject matter and for enabling 2 or more heads to work together on the same. Sitting in a division bench is not as if 2 single judges sit. In a division bench or in a bench of larger strength, there is a lot of discussion in between, clarifications made, situations jointly analyzed, and positions in law getting evolved. Under section 98, when judges differ in opinion on a point of law, the matter is required to be placed for opinion of the third judge or more of the judges as Chief Justice of the High Court deems fit, and point of law on which a difference is arisen is decided by the majority and the appeal is decided accordingly. It is to be seen that under the proviso to 98(2), hearing by a third judge or more judges is only on the point of law on which the division bench could not concur. There is no hearing of the appeal by the third judge or more judges on any other aspect. Under section 98(2) CPC, in case an appeal is heard by a division bench of 2 or more judges, and if there is no majority and if the proviso is not attracted, the opinion of that judge or of the equally divided strength in the bench which concurs in the judgment following or reversing the decree appealed from, such decree shall stand confirmed. We are not on that, my lords. The Kerala High Court Act has provided for the powers of a bench of 2 judges under section 4. It is clarified thereunder that if the judges in the division bench are of the opinion that the decision involves a question of law, the DB may order that the matter or question of law be referred to the full bench. Needless to say, it should be a question of law on which there is no binding precedent. Under 23, that, my lords, can be skipped. An interesting contrast is made by his lordship, my lords, to 392 of CRPC. Under the Code of Criminal Procedure, the position is slightly different. 392 reads as follows: procedure when judges of Court of Appeal are equally divided. When an appeal under this chapter is heard by a High Court before a bench of judges and they are divided in opinion, the appeal with their opinion shall be laid before another judge of that court, and that judge, after hearing as he thinks fit, shall deliver his opinion, and judgment or order shall follow that opinion, provided that if one of the judges constituting the bench or where the appeal is laid before the other judge under this section, that judge so requires, that appeal shall be reheard and decided by a larger bench of judges. Quite different, my lords, from 98, as your lordships have seen. And ultimately, my lords, after holding that 98 yields to 23,
Reheard by the third judge, CRPC provision. Why it provides for rehearing? CRPC provides rehearing on acts also. CPC on 89, no, only on question of fact. Unless your statute, what act provides for that, isn't it? Only on point of law, this is not on the acts. There is a difference of opinion between consider and answer that. Not more than that. You can't go back. What angle is that?
yes, my lords. My lords, what I'm respectfully submitting is, regardless of what we may all argue, your lordships, and we are not privy to the reference order made by the Honorable Chief Justice, my lords. That, of course, is in your lordship's file. But under the statutory regime, and keeping in view the two opinions rendered by the learned judges, my respectful submission is that your lordships would be confining this reference to the question on which the two judges have differed. And the point of difference, my lords, appears to be only as to the effect of the FTC and the 32 so-called temporary posts and their effect on the seniority list. And that, my lords, I draw some strength from para 69, which concludes the reading of this judgment. In my humble view, if the purpose behind the requirement of a matter be heard by a bench of not less than two judges is to be achieved, in the event of the two judges being unable to agree either on facts or law, the matter should be heard by a bench of larger strength. Then only the members of the bench of such larger strength would be able to exchange views, discuss law, and appreciate various factual and legal positions. The conspectus of the various provisions, in my view, calls for a comprehensive legislation for handling such situations of a bench being equally divided in its opinion either on law or on facts while hearing a case which is otherwise required to be heard by a bench of not less than two judges, both civil and criminal. It is for the High Court and legislature of the state concerned to take further steps in that regard. I may, just as an aside, my lords, dehorse the lists before your lordships. Also, respectfully urge the Honorable Court to consider on the administrative side whether, my lords, the Karnataka High Court Act now merits some amendment rather than reverting to the general law under 98. That's just a larger, my lords, thought that I'm placing before your lordships, because in para 69, no frame. Okay. There is no provision, my lords, akin to 23. No doubt, my lords. But in a situation where two learned judges differ, it's 98 that would govern. Just take out the
So far as CPC is concerned, appeals 98. But whether in case of if there's a divergence of opinion,
Please.
the chief have the power to assign that to a larger court.
That would be, in fact, under 98, my lords. In fact, hitherto, if your lordships would recall, as a matter of practice, when two learned judges differed, it would go to a third judge, a sort of tiebreaker. This is one of those rare cases where the matter has come before your lordships as a full bench. Ordinarily, my lords, references to full bench were when one division bench was not able to agree with the earlier division bench. And on that point of difference, a reference would be made, either to three or in some cases even five learned judges. As your lordships are aware, the scope of appeal against a 227 order, His Lordship Justice Sodhi's decision, went in fact to a bench of five judges. But that is, my lords, where a division bench differs. Here is a case where two learned judges in a division bench have differed with one another. And there, my lords, subject to correction, the Karnataka High Court Act has no special or specific provision for reference. Would my lord see section 7, my lords? Grateful. Reference to a full bench wherein any proceeding pending before it, any question of law or usage. Which is the section for the Chief Justice's power to allocate? Oh. Grateful, my lords. Wherein any proceeding pending before it, any question of law or usage having force of law arises, a bench consisting of not less than two judges of the High Court may, if it thinks fit, and shall, if it differs from the view taken by a similar bench of the High Court on the said question, refer to a full bench of the High Court the question of law or usage having force of law. The decision of the majority of judges comprising a full bench shall be the decision of the High Court. But in the situation that we are now confronted with, the Act is silent, and the necessary power of the Honorable Chief Justice, my lords, is to be traced once over to section 98.
Assignment of cases could be placed to any provision or just as a master rule.
See, my lords, 8 is the powers of the single judge. Yes. And 10 is the power of the bench. Now, over and above that, it is the administrative power of the Honorable Chief Justice, my lords, to allocate. But in a situation like this, and that dichotomy your lordships are seeing in our own Honorable High Court, that sometimes it is before one learned judge, sometimes it is a full bench. That really doesn't matter, but I'm just placing before your lordship that there is some vacuum, my lords, in our statute as far as that question is concerned. But one thing is clear, my lords, that whichever way the matter arrives before your lordships, in the absence of any provision akin to 23, it is 98 that would apply. And it's the point of law on which there is a difference that your lordships would be resolving, my lords, the conflict. That position is clear because 392 of CRPC would be inapplicable in a civil service dispute. May I now, my lords, take your lordships first to the written notes that we filed before the division bench, my lords, prior to the judgments being delivered, we have also filed before your lordships a preliminary written submission in this reference. And I would like to take your lordships to both those because my submissions are really within that square. Is that written note? Filed on 11/12/2025. No, before the division bench. Yes. Please take, my lords, our written note dated 11/12/25. In that note, my lords, at page 6, I have annexed the written submission that we had originally filed before the Honorable Division Bench. It's a short note. Permit me to please read that first, my lords. Grateful. Sorry, going back to the High Court rule. The Chief Justices. Right. And so it is the full in this situation, generally. And just to answer your lordship's earlier question about the powers of the Honorable Chief Justice, my colleague has pointed out Rule 6 of the rules expressly vests the Honorable Chief Justice with the power, my lords, to constitute benches and allocate or distribute the judicial work. Rule 6 is there. That's a general power. Yes, my lords, of the High Court rules. Rule 6 of the High Court of Karnataka rules 1959. To close this. Should I read Rule 6 to your lordship? Benches shall be constituted and judicial work of the court allotted or distributed to them by or in accordance with the directions of the Chief Justice. And on reference, when a single judge refers a case to a bench, or when a bench of two judges refers any question to a full bench, then the papers of the particular case shall be placed before the Chief Justice for reference to a bench or for the constitution of a full bench. Yes. Now, on my note, written submission on behalf of the respondents so and so, that is appellants in writ appeal 1312. The respondents are judicial officers in the state of Karnataka working as district and sessions judges in courts across the state. I'm at page 6. Grateful. It is submitted that as on 1/3/2015, there was a total vacancy of 45 posts against the 65% promotion quota in the cadre of district and sessions judges. This is basis the Surrey Joinder, my lords, at the footnote filed by the Honorable High Court on the administrative side. It is further borne from the records that by notification dated 26/3/2015, 48 additional post bar vacancies in the cadre of district and sessions judges were created. In light thereof, the respondents, that is us, my lords, While notifications dated so and so 3315 and 13/8/2015 were promoted and appointed against clear and substantive vacancies in the 65% promotion category that had arisen in the cadre of district judges. The material on record clearly enunciates that the quota rule was strictly followed. Whereas respondents 1 and 4, that is the writ petitioners, are district and sessions judges appointed to the post on 1/2/2016. So, my lords, a clean 1 year after our promotions were made against regular vacancies in the 35% quota earmarked towards direct recruitment long after the promotion of these respondents. The seniority of the present promotee respondents has been reckoned from 33/2015 and 13/8/2015, the date that they were promoted to the cadre of district judges against existing vacancies, and not from any anterior date. I just pause here for a moment, my lords. The writ petitioners appointed as of 2016 chose to prefer the writ petition in 2020. Of course, we did not file objections in the writ petition. We, my lords, relied on the stand taken by the Honorable High Court, and therefore the question of us having pleaded any laches does not arise. But your lordships nonetheless would keep in mind the fact that 2016 appointees filed the writ in 2020, and in the writ made a reference to some representations they had made on the administrative side, and a hearing that took place in 2018. Now I continue, Lords. It is further submitted that Articles 233 and 234 under Chapter 6, Subordinate Courts of the Constitution of India, provides a complete code for regulating recruitment and appointment to the district judiciary and subordinate judiciary. The said position has been enunciated by the Honorable Supreme Court of India in State of Bihar versus Bal Mukund Shah. Therefore, the appointment and promotion of district judges is governed by the Karnataka Judicial Services Recruitment Amendment Rules 2011. The block period mentioned in the official memorandum dated 5/7/1976 and any analogous provisions under the Karnataka Civil Services Rules 1977 are not applicable to district judiciary. And on this point, my lords, the learned judge who has allowed the writ appeal has concurred with our submission that Bal Mukund Shah is the last word on this question. And the question of 2016 appointees raising a question of block period going back to an uncertain period of time does not arise. It is therefore submitted that the final seniority list dated 16/3/22 issued by placing the present respondents higher than senior to respondents 1 to 4, that is writ petitioners, does not suffer from any infirmity. It is most respectfully submitted that the impugned order dated 19/7/23 passed by the learned single judge is erroneous and contrary to the record. This was really, my lords, the realm in which the division bench considered the question. And though your lordships have seen both the views, may I trouble your lordships with just a few paragraphs to try and, my lords, fit my submission into the point that I first made as to what is it that the learned judges. (39). Please, my lords. Please first take, my lords, para 37 of Justice Anu Shivaraman's opinion, which allows the writ appeals. Great. We must come back to note 1. Please. Para 37, my lords, of her ladyship's view, which is at page 81, is it? Printed page 81. In the nature of the challenge raised by the direct recruits, the only question which requires to be answered is whether the private respondents were promoted in excess of their quota. If not, the writ petitioners who were appointed by direct recruitment on 1/2/2016 would not have any right to claim a revision of seniority on the ground that the promotees are in excess of the quota. It is an admitted fact that direct recruits can at best claim seniority only from the date of their appointment. The question therefore is, what was the cadre strength in the post of district judge as of 1/2/2016? The first question which requires an answer is, what is the meaning of the expression cadre and what constitutes cadre strength? In service law, cadre means a designated group of officers that group together. The Karnataka Civil Services Rules defines cadre as follows. 8.7. Cadre means the strength of a service or part of a service sanctioned as a separate unit. Kindly note, my lord, there is no exclusion of any temporary posts from this definition. The apex court in the case of Baleshwar Das and others reported in so and so held at para 9 and 24 as follows. I will skip that because your lordships have seen that once before. Then my lords, Pushpa Rani is referred at para 40. Please come to para 41. The appellant high court had taken a specific stand that the cadre strength was 314. The notifications and orders issued by the government on the basis of which such a contention was raised have now been placed before this court by R3. It is clear that vacancies which are permanent in nature or which have continued from year to year on the basis of extensions duly granted by the state governments and which form part of the cadre have to be taken into account while working out the ratio set apart for promotion. This is the crux, my lords. A division bench of the High Court of Kerala, in its judgment dated 29/6/2017, dealing with an identical situation, held at para 10 and 11, which reads as follows. And I place some, my lords, strong reliance on this judgment because this judgment settles the question. It is pending in SLP. Notice has been ordered, but there is no stay thereof. And the view taken by the division bench of the Kerala High Court is in consonance with the view of the Honorable Supreme Court in Ganesh Rao's case. I'll be just coming to that presently. So in the judgment of the High Court of Kerala at para 10, the second ground taken was that temporary posts cannot be included in the permanent cadre. Lords, I feel here, if your lordships permit me, may I place the Kerala judgment itself? Because her ladyship has in fact also relied upon the view taken therein. Please permit me to go to the Kerala judgment. This was a division bench judgment, my lords, of 2017, where lordships would find the facts were almost identical. Maybe about, my lords, 45 minutes to an hour. Please, if your lordships could have it on Tuesday, I could have the benefit of being before your lordships in person, my lords. Wednesday, my lords. Please. We'll start with Kerala. Please. As your lordships please, lords.
Tuesday is not permissible. Inconvenient.
The difficulty is not the, my lord, the other judge has to come from Dharwad, we are living everywhere.
So grateful.
ಇದನ್ನಿಟ್ಟು ಹಿಂಗೆ ಇಡು, ಇದೆಲ್ಲ ಬೇರೆ ಇಡು, ಜಡ್ಜ್ಮೆಂಟು ಅಲ್ಲೇ ಇಟ್ಬಿಡು, ಅದನ್ನ ಇಲ್ಲೇ ಇಡು, ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲೇ ಇಡು. ಸತೀಶನ್ ಕೊಡು. ಹೇಳ್ತೀಯಾ?
ಅದು ಹಿಂಗೆ ಮೇಲೆ ನೋಡ್ಕೊಂಡು ಇದು ಬೇರೆ ಇರುತ್ತಲ್ಲ ಸೈಡಿಗೆಲ್ಲ
Contempt.
ಕೈಯಲ್ಲಿ ಇಟ್ಕೊಂಡು ಬರ್ತೀವಾ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಇದೊಂದು ಕೈಯಲ್ಲಿ ಇಟ್ಕೊಂಡು ಬರ್ತೀವಿ ಇಲ್ಲ.
Pronouncement of order. Serial number 1, Mohammed Tahir. Okay. ಬರ್ಕೊಂಡಿದ್ದೀನಿ. Rejected.
Please, ma'am.
ನೀವು ಅರ್ಧ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಲ್ಲ ಕೇಳಿಸಿದೆ. ನನಗೆ ತುಂಬಾ ಹುಷಾರಿಲ್ಲ, ಸತ್ತೋಗ್ತಾ ಇದ್ದೀನಿ. ನೀವೇ ವ್ಯವಸ್ಥೆ ಮಾಡ್ಕೊಡ್ಬೇಕು ಅಂತ ಕೇಳ್ಕೊಳ್ತಾ ಇದ್ದೀನಿ.
ಬೇರೆ ಮೇಲೆ ಯಾವ ಕೇಸ್ ಮುಂದೆ ಅಲ್ಲೇ ಹೋಗ್ಬೇಕಮ್ಮ, ನಮ್ಮ ಮುಂದೆ ಇರಲ್ಲ, ಬದಲಾಗುತ್ತೆ.
ಇಲ್ಲ, ನೀವು ಕ್ಲಿಯರ್ ಎಲ್ಲ ಸ್ವಲ್ಪ ಗೊತ್ತಿದೆ, ನನಗೆ ವ್ಯವಸ್ಥೆ ಮಾಡ್ಕೊಡಿ.
ಅದು ಮುಖ್ಯ ನ್ಯಾಯಮೂರ್ತಿ ಅವರು ಬೇರೆದಾರ ಮುಂದೆ ಕೇಸ್ ಕೊಟ್ಟಿರ್ತಾರೆ, ನಮ್ಮ ಕೈಯಲ್ಲಿ ಇರಲ್ಲ. ರಿಜಿಸ್ಟರ್ ಹತ್ರ ಹೋಗಿ ಅಂತ ಹೇಳಿ.
ಅಣ್ಣ, ನೀವು ವಾಟ್ಸಪ್ ಮಾಡಿದ್ರೆ ಬರೀಲಿಲ್ಲ, ನನಗೆ ವ್ಯವಸ್ಥೆ ಮಾಡ್ಕೊಡ್ಬೇಕು. ನೀವು ಆಗೋದಿಲ್ಲ, ನೀವು ಬಂದು ನಾನು ಮಾಡ್ಕೊಡ್ಬೇಕು ಮಾಸ್ಟರ್.
ಇವ್ರು ಕೇಳಿ.